So what is wrong with you? And she picks you up and brings you back home, and then you beat her up.
This man walked into court with his lawyer like it was just another routine case, but things went downhill fast. After his girlfriend picked him up and took him home, he decided to end the night by assaulting her. You can see from the start that the judge already looks fed up, like she's heard enough before anyone even speaks. And honestly, who could blame her? This guy clearly thinks he can do whatever he wants without facing the consequences. His lawyer is doing his best to stay calm, but you can tell he knows his client's image is falling apart right there in the courtroom. Some people treat court like it's a place to make excuses instead of a place to take responsibility. Let's see how Judge Boyd handles this disaster. My bet is she's not showing any
Is this a
mercy.
plea?
Yes, Your Honor.
All right, can I have a file stamp for a plea, please? Court is calling 2025 CR 0022720 State versus Alfredo Campos. Could I have parties announced?
For the state of Texas. Renee Munoz on behalf of Mr. Campos.
All right. Counsel, you received all discovery. Did you review it with your client?
Yes, Your Honor, that's correct.
Court will find that the state is in compliance with discovery. Is there an application?
No, Your Honor.
All right. Mr. Campos, did you review the true bill of indictment with your attorney? Did you understand it? Counsel, do you waive the reading of the indictment?
Yes, Judge.
State, are you proceeding on the indictment as presented?
No, Your Honor, state will proceeding. Additionally, Your Honor, state will waive the repeat offender enhancement. Also no objection.
Okay. All right. Did you review the document entitled court admonishments with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, sir.
All right. In count 2, you're charged with assault, family household member with a previous conviction. That's a 3rd-degree felony. Range of punishment is anywhere from 2 to 10 years in prison and up to a $10,000 fine. If you have a plea bargain agreement with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes, sir.
You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent. Did you understand by entering this plea you were giving up those rights?
Yes, sir.
And did you intend to give up those rights and enter into a plea in this case?
Yes, sir.
Counsel, has your client been able to provide you with any defenses?
He has.
Do you believe he has a rational as well as a factual understanding of the charges against him?
In my opinion, he does.
Do you believe he's currently competent and was legally sane at the time of the offense?
That is correct, Judge.
Sir, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea? Anyone promised you anything other than the plea? Are you satisfied with the way you've been represented?
Yes, Your Honor.
Are you a U.S. citizen?
Yes.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
Yes.
According to the plea, punishment is to be assessed at 3 years in the prison. There's a $1,500 fine. State is proceeding on count 2. There's an affirmative finding of family violence. There's to be no contact with the complainant. Did you understand that to be the plea?
Yes, sir.
Defense, is that the plea?
Yes, Judge.
State, is that the plea?
It is, Your Honor. I did want to mention that when you get to the stipulation.
Right. Did you understand with an affirmative finding of family violence, you're not allowed to own or possess any weapons or ammunition?
Yes, sir.
And you're not allowed to be designated as a primary custodial parent?
Yes, sir.
Right. Knowing that, do you still wish to continue with this plea?
Yes.
Right. Did you review the waiver of appeal paragraph with your attorney?
Yes, sir.
Did you understand it and sign it in both places?
Take a look at the defense lawyer. He's staring at the floor like he's searching for an escape route. You can tell he already knows his client's done for. He's just waiting for Judge Boyd to deliver the final blow. And honestly, no one could fault her if she did. This guy isn't just careless, he's dangerous. The whole courtroom changes the second Judge Boyd locks eyes with him. The tension is thick enough to feel. Everyone knows exactly what's coming. He's not walking out of there free. Judges usually try to keep their emotions in check, but when someone's violent behavior crosses the line, even they can't hide their frustration. Cases like this sometimes end with plea bargains, but once the evidence and the victim's injuries come up, that leniency vanishes. I just hope Judge Boyd gives him the full punishment, because letting him off would be a mistake. People like this only learn when the system makes an example out of them, and that lesson is about to hit hard.
Did you understand it and sign it?
Yes.
In both places?
Yes.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, sir.
Counsel, are there any such motions?
No, Judge.
Then to the offenses charged, how do you plea in count two? Guilty, not guilty, or no contest? State any evidence?
Your Honor, this time state the evidence states exhibit 1 with all attachments. No objection.
All right, did you review the waiver and stipulations with your attorney? Did you understand it and sign it in all the appropriate places?
Yes.
Again, did you understand you have a right to a jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent?
Yes, sir.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there will be no live testimony? Did you understand?
Yes, sir.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments. The court has reviewed the same. Court will find there is sufficient evidence to find you